going to interfere with my recording equipment. That's not going to sit there.
Is it interfering?
It's probably going to make it set up on the other side here. So yeah, that's going to cause a squelch.
Because it's not a transmitter.
No, I'll tell you what, set up over there.
Turn plug over
that
there?
side. I don't know.
Well, then I'm not set up with them set up. What I'm saying is, mine is not a transmitter. You don't understand it. It's not a transmitter. It's not going
I
to
don't
interfere
want it
with
to
that.
interfere with my recording
Again,
equipment, sir.
It's not going to.
Sir, I'm telling you, I have a job to do.
Put it over. No. It's yours. We're supposed to. All rise. Honorable David Peoples is presiding.
May be seated. Your Honor, is your mic on, sir?
Pardon?
Yes, it is
Good morning. My name is David Peoples. I'm a semi-retired judge from San Antonio. The law of Texas has some very wise procedures, in my opinion, which say in a suit like this one, somebody from the outside has to be brought in to hear it. I've been chosen to do that. That's why I'm here. I'm going to call for hearing the case of the state of Texas, ex-rel Cindy Stormer versus Susan Hawk, District Attorney, and get announcements by everybody. Mr. Wilson, let's start with you.
Your Honor, Patrick Wilson from the state of Texas.
William Little, associated with the County Attorney's Office of Ellis County, President of the state of Texas.
Ray Reich, with Ellis County Attorney's Office for the state of Texas.
Vance Hines with the Ellis County Attorney's Office and also for the state of Texas, Your Honor.
And Montgomery Moran, attorney with the County Attorney's Office, also for the state of Texas.
Dan Higgins, Your Honor, for Ms. Hawk, and this is the rest of our team, Judge.
Doug Alexander for defendant Susan Hawk.
Brett Walker for the defendant, District Attorney Susan Hawk.
Your Honor, I'm Charlotte Aldis, and I'm also here on behalf of Susan Hawk.
And I'm Kelly Coolidge, Your Honor, on behalf of Cindy Storm.
Mark Haney, Your Honor.
It's Cindy Storm.
This is Ms. Stormer, okay. Let me say something that I told the lawyers when we talked back there. Excuse me. I have given the electronic media permission to stream this proceeding and to tweet and to take still photography. I've told them that if it becomes a distraction, I will stop it. This is a deviation from my long-time policy, but they convinced me that I should do it. And so I have allowed that, and I told the lawyers that too. Let me just talk about timing. I have no idea how long this is going to take, but it may take a couple of hours, maybe less, maybe more, but we're not going to stop for lunch rigidly at noon. If we need to go into the lunch hour, we'll do it, but at some point I'll call a halt when I think we've had enough discussion. So let's talk about our agenda for today. Certainly what we are here for, one thing we're here for is to talk about the question of whether I should authorize the issuance of citation, which the statutes say I have to do before this suit can go forward. And that's a discretionary decision, and I'm looking forward to hearing discussion by everybody inside the rail on that question. And as I told the lawyers, I've read everything they've sent to me, which was a good bit, and which is very well done, by the way. Excuse me, there's something in the air and something where I came from, and that's the problem. But that is one issue. Are there other issues that anybody wants to address and discuss today? There was some discussion about an attempted intervention by somebody. We need to do this.
There's been, for lack of a better term, a rogue filing made in this court by a lawyer, I think of suspect and well-documented suspect character. I think Ms. Moran can actually address that with the court if you'd like to hear from her.
And the relief you would be asking for is what?
To strike those pleas.
Does anybody oppose that request by Mr. Wilson?
No opposition.
The motion to strike that attempted intervention or whatever it is granted. If you got an order, I'll sign it.
Yes, sir.
May I request, Judge?
Have they seen
I have not.
it? Go ahead and bring it up so I can be looking at it.
We approve it, Your Honor.
I signed it. Is there anything else that anybody wants to take up before we get to the other discussion?
Nothing from the state, Your Honor.
Okay. Mr. Wilson, you and others on your side may go ahead and talk about anything you want to. At some point, it'll be time to stop, and I'll hear from the other side. We're going to go back and forth. I'm not going to be, rigid and technical on that, but You have the floor.
I think the state's position is clear, and I think ours is pretty straightforward. However, I'm going to defer to William Little to advance our argument as to why citation should be issued. The defense has advanced an argument related to the Americans with Disabilities Act as preempting the issuance of citation. I'm assuming they're going to advance that argument here this morning. To rebut that argument, I'm then going to rely on Ray Reich to respond to that argument. So at this time, with the court's permission, I'd like to defer to Mr. Little.
Mr. Little?
Thank you, Your Honor. May it please the court, counsel, parties. This case was brought initially by Cindy Stormer, who is now the relator in this case. And acting pursuant to statute, Chapter 87 of the Texas Local Government Code, and at the behest of the County Commissioners Court of Dallas County, Texas, the county attorney of Ellis County was appointed the task of assuming responsibility for the handling of this matter on behalf of the people of the state. Our first appearance in this case was made by virtue of the second amended petition for removal. The court has signed orders of a preliminary nature, realigning and recognizing parties, and scheduling this hearing for today. The case of the state is straightforward. At this time, we're here to ask for the court to authorize the issuance and service of citation on the defendant so that the case may proceed to a trial before a jury. This case is based entirely upon the statute in Chapter 87 of the Texas Local Government Code, which authorizes a resident of Dallas County or any other county who has a complaint against county officials, such as the district attorney, Ms. Hawk, to request, file a petition and seek removal or ouster of that official based upon the enumerated grounds in the statute. The case, as the state now presents to the court, is that we have asserted two grounds derived expressly from the statute, seeking to justify the removal or ouster of this defendant. The two grounds are incompetency and official misconduct. There is no disagreement about the applicability of the statute. There is no disagreement amongst the parties regarding what the statute says about the definition of incompetency or official misconduct. For purposes of this hearing, we would remind the court that incompetency means either gross ignorance of official duties, gross carelessness in the discharge of those duties, or unfitness or inability to promptly and properly discharge official duties because of a serious physical or mental defect that did not exist at the time of the officer's election. Any or all of those are grounds for removal based upon the county officer's alleged incompetency. The second ground, as for the basis of the civil ouster action, is official misconduct. And the term official misconduct is described as intentional unlawful behavior relating to official duties by an officer entrusted with the administration of justice or the execution of the law. The term includes an intentional or corrupt failure, refusal, or neglect of an officer to perform a duty imposed on the officer by law. These statutory provisions are contained within Section 87.022 of the Texas Local Government Code, the action which regulates this ouster proceeding. I do not believe, based on filings from the defendant, that there's any disagreement about which statute governs this action, the role of the state in this action, the authority of the state in this action, or what the statute provides for the grounds of removal. When the state filed its second amended petition for removal, affidavits were attached to provide information to the court justifying, at least in a preliminary way, because nobody can contend here that this issue has been thoroughly discovered or the evidence thoroughly developed. We're at a very preliminary stage. In fact, we are at the initial stage of this case. As the court well knows, you have discretion to decide whether citation should issue and be served upon the defendant and the case go forward, or whether citation should not be issued. And what we're here to do today is present to the court our argument and belief that there is sufficient reason to believe that citation should be issued and the case to go forward. As we understand the defendant's response at this time, it comes in two forms. Number one, they have submitted affidavits yesterday afternoon alleging that there is no evidence to support an allegation of incompetency or official misconduct. Essentially, we have 5 affidavits and they have 12. And that presents to the court an opportunity to recognize the fact that a resolution of these conflicts is necessary and that resolution of these conflicts can only be accomplished by a jury trial to determine whether any of these grounds for removal are true. There is sufficient information before the court to justify the commencement of this lawsuit, proceedings through discovery, and eventually possibly a hearing on whether or not the defendant should be removed from office temporarily, and then a trial for removal on a permanent basis. The court has been presented with a variety of information that's very difficult to reconcile, since none of these affiants or witnesses have been deposed, none of them have testified, and they've all presented essentially conflicting evidence, which presents the court with the issue, how do you resolve that? Well, you can't. That's why citation needs to be issued here, so that this issue can be fully developed during discovery and evaluated in preparation for trial. And so as a threshold matter, we believe that the state has presented sufficient information to identify the nature of the relief being sought, the statutory grounds authorizing that relief, and the statutory grounds that regulate how this is to be conducted. Now, a moment, if I may just digress, what might be the reason for the legislature to include a preliminary threshold determination like this on the issuance of citation? I'm not aware of another civil action in Texas jurisprudence that allows or provides for such a threshold gatekeeper type function. And therefore, the inclusion of this threshold gatekeeper function must be a recognition by the legislature that this is a serious event. We don't want everybody who's been arrested or is being prosecuted by a district attorney to be filing a lawsuit seeking the ouster of those people, because that would cause the course of justice in the state to grind to a halt. Therefore, the court has been vested with the authority and the discretion to make a preliminary determination. Now, the statute we're here is a very brief statute. It's been enacted and enforced in this state since about 1876, when our Constitution was promulgated and approved. There are not that many cases on the statute. And so we're kind of plowing some fresh ground here. We don't have a lot of authority to offer you in this regard. But I think the essence of the issue is the court is tasked with looking at the four corners of the petition and the evidence presented in support of it to determine whether or not this merits the issuance of citation, so that discovery can proceed, the case can be evaluated, and a determination can be made based upon that discovery whether a trial is necessary or a temporary removal is necessary. That's what we're asking the court to do right now. To rule otherwise would mean that the court has been placed in what I think is an untenable position. You have to try and resolve 17 affidavits that have been submitted as a preliminary nature. And we've yet to really have a formal appearance by the defendant, because the citation is not issued in this case. Finally, with regard to the request for an evidentiary hearing on the temporary replacement of the district attorney, that has been argued by the defendant as being something that should follow if and only if the court decides that citation should be issued. And we agree with that. If the court deems that an evidentiary hearing is necessary, that's not a problem. We can get that set in 60 or 90 days after some preliminary discovery, and then have that hearing to decide whether or not the situation justifies such radical and important action by this court. But the preliminary issue, and a relief that we first asked the court for today, is to recognize that a statute has been properly invoked. The state has made an appearance in accordance with the procedure that's been outlined by the statute, and now the court is being asked to authorize the issuance of citation. The statute doesn't really provide any guidance to the court on how that decision is to be made, so we're happy to be here today to address the court's issues and to argue with counsel to see how we should proceed here. But that, in essence, is the state's case. That's at this time and at this juncture, and that's what we're asking the court to do today.
Thank you. Mr. Wright.
May I approach the bench, Your Honor?
Yes, sir. How much time do you want to devote to this ADA issue?
as little as necessary, as much as required.
Why don't you give me the basics, and then after I've heard Mr. Alexander, I'll decide whether I want more.
I'm sorry, what did you
And
want?
then after I've heard from Mr. Alexander's side, I'll tell you if I want more.
I didn't hear the first part.
Just give me the basics without too much detail.
Okay, the basics are that the ABA has two titles, Title I and Title II. There are very few cases, as you might imagine. I don't think they've found one involving an elected official that sought coverage under the ADA, and we don't think there is a case either. The two they've cited, one of them deals with Title I, an employment case. The other one deals with Title II, which is a public accommodations case. Title II cases can't be used for an employment-like dispute. If you have a problem with an employment case, you can't reach Title I, for want of a better term. And that's what the Oklahoma case that's mentioned in here discusses. The Oklahoma case sets out the whole statute, the applicable parts of Title II, and there's a tenured professor, don't get excited, it says XRL on it, but it's not XRL about this. It's about a professor. And so the professor couldn't get to Title I, so they tried a Title II case. One of their two cases, their Vermont case from the Second Federal Circuit, deals with non-employees. And so it's not really applicable to this proceeding. The Oklahoma case explains you can't go to Title II. Louisiana, the Fifth Circuit says the same thing. With regard to Title I, you have to prove, among other things, to reach some of the protections that you're an employee. She's not an applicant, so she's not entitled to the applicant areas of the protection in Title I. But she is she an employee? And we think there are 16 factors listed. The Clackamas case, I'm sure I pronounced it wrong, is a Supreme Court case that says you can go to the EEOC compliance manual and look at those 16 factors to try to determine whether she's an employee or not. And we think on the whole she's not. None of this was cited in any of their materials. They just cite the two cases for a kind of a rudimentary point. That's what I've actually said almost everything I was going to say, Your Honor.
Okay. Thank you. Anybody else on your side, Mr. Wilson?
Not at this time, Your Honor.
Mr. Alexander?
Go ahead.
Go ahead.
Yes.
Your Honor, Brent Walker for the District Attorney. For clarity purposes, I wanted to tell you briefly the outline of how we're going to present our argument. First, I will begin with a sort of summary statement as to why we're opposing citation today. Mr. Alexander will then rise and he will discuss and focus and grapple with this statute itself and how this court should interpret it. And then Mr. Alexander will turn to what we believe is the real gravamen of the state's complaint, and that's this issue, this unprecedented, this unwarranted, and we believe improper attack on the mental health of the district attorney. Mr. Alexander will also address during that time period this allegation as to whether or not the issues regarding the DA's decision as far as terminating people, whether that is grounds for potential ouster. I will then rise and talk about the remaining allegations. That includes the allegations regarding finances, the allegations regarding ignorance of her duties, and the allegations regarding carelessness of her duties. Then we will summarize, and that will be how we're going to present our argument, Your Honor. We oppose the citation for three primary reasons. The state's allegations are legally insufficient, factually insufficient, and we submit they're against the public policy of both the state and the federal government. In performing this analysis, we believe the court should be guided by a couple of things. First, the issue of evidence is raised just by the state now. We previously discussed with the court whether this should be a full evidentiary hearing or not. Make no mistake, our position is that you can review the state's pleadings and the state's evidence, and this court can conclude, based on the inadequacy of that pleading and the inadequacy of that evidence, that the state has not met a burden to show that there's a potential for ouster here, and the court can deny citation. It is true that late yesterday, in response to a filing by the state on Tuesday requesting temporary suspension of the district attorney, we did attach evidence in a response to that motion. And that evidence we submit to you both rebuts and clarifies that many of the things the state says is not actually what happened, but it also provides the court context as to the before and after picture, because we do not deny that District Attorney Hawk was suffering from an issue with depression and she sought treatment, and the evidence, which is undisputed, is that she is better and everything is fine. So the court doesn't need to consider that evidence. It's there in the record if the court chooses to do so. But again, this can all be resolved on the inadequacy of the state's own pleadings and the inadequacy of the state's own evidence, which is premised on the allegations of 5 disgruntled employees who were terminated by this district attorney, individuals who have not been there for months, individuals whose allegations themselves involve simply quibbling and disagreement with how the district attorney wanted to do certain things. But none of this will rise to the level of ouster. And so on the issue of evidence, we believe the court can just look at the pleadings, but it can consider that other evidence if you'd like, because frankly, this is something that you are vested with a lot of authority. This is a serious matter. The court is the guardian here to make sure this is proper. If you want to consider the evidence, it's unreviewable in your discretion. You can do so if you'd like. The second thing is I think we need to focus on the terms of the statute, and that's what Mr. Alexander is going to focus on initially. And I think when we do that, we will show that what you have is a lot of allegations that singularly and independently do not rise to the level of ouster. And the statute requires that. You don't get to file a bunch of 20 different allegations, all of them inadequate, and add them together and say, well, ouster is appropriate. So I think the court needs to wrestle with the statute and apply it to the actual allegations here. With these guideposts, we believe we can show this court that with respect to the mental health issue, which Mr. Alexander will argue, that is both preempted by federal law and unprecedented in the history of this jurisprudence to try to out someone based upon their mental health. And we don't think the court should issue citation and bless this action because of what it would mean for the public policy of this state.
Let me ask you this, do you say that the state wants to oust her because of her condition or because of conduct that might have been related to that condition?
Well, Mr. Alexander will get into this further. The state clearly states that because she suffers from a mental defect, an archaic language from 1879, that alone is sufficient to oust her, as if she is somebody who cannot function as a district attorney because of her mental health. And so we believe that argument is plainly an issue that would be preempted by federal law and inadequate. Further, we will show that the allegations here, separate and apart from the mental health issue, singularly do not rise to the level of ouster. Every office in this country has personality conflict. People in the day-to-day of stressful jobs will not get along with everyone. In every district attorney's office in this state, there will be situations in which the district attorney will have to fire certain people. It happens. The fact that this district attorney terminated certain people, that's not going to be grounds for ouster. The other issues raised with regards to issues regarding finances, I think the court will see when you really drill down that all of those issues are not things which rise to the heavy burden of the statute, which is to show that the duties of the district attorney were not being fulfilled. These are what I think are simply quibbles, disagreements, but nothing which shows that the duties of the office were not fulfilled. And with that, I'll turn it over to Mr. Alexander to address his argument.
Thank you, Your Honor. Please, the court. The issues today really are cleanly framed. We're not going to be dealing with a temporary suspension issue. I'm not going to get into preemption today. I'm going to focus on the plain language of the statute. And so
does that mean that you don't consider the ADA preemption argument all that strong?
It doesn't mean that, Your Honor. What it means is that I believe that you can resolve this case on the plain language of the statute without reaching preemption. And so what I don't want to do is to waste my time today with an alternative argument when the strong argument is the plain language of the statute.
Are there any cases in the whole country that hold that the federal Americans with Disabilities Act means that a state office holder who is shown to have serious problems in doing the job that are related to a mental condition, that they're
I'm not aware of any.
Okay. Now, I'm not saying that's the state of the evidence, but.
Yeah. No, I
And then let's
appreciate
move on to
that.
something else.
Yeah, no, that's fine. So I'm going to focus on the plain language of the statute. And in particular, I think the real gravamen of the complaint, from where it started out with just Ms. Stormer and then has now gone on to the state, really boils down to, and I've given you a bench book, and this is under tab 1. It's section 2C, and that's the provision that defines for incompetency, unfitness, or inability to promptly and properly, all of that, the business about the serious physical or mental defect that I think that all of us have been wrestling with. And why don't we flip to tab 2, because that will help this. This is the legislative history that we put together for your honor. So the language that we're grappling with goes back to 1879. What's interesting to me is that, you know, in the course of my 35-year career, I don't know how many statutory construction cases I've been involved with, you've been involved with. I don't know that I've ever seen a case where there's a statute more than a century old in which key language has never been interpreted in any reported decision. And so, faced with that, we're left to grapple with what does it mean? And that's what I'm here to address today. I think that I want to get everything else pushed out of the way. I want to talk about the plain language of this provision. And that's where I intend to spend my remarks. I welcome Q&A, because it's a wrestling match in my mind as to what do we do with that? What's a physical defect? What's a mental defect? Where does that come from? And I will tell you that I have a thesis. This is a thesis, and that's all I can call it. I was going to say you be the judge, but in fact you are the judge, right? So what I'm going to do in the time I'm going to take, and I'm so grateful that I'm not confined to 20 minutes, which is where I usually live, I'm going to walk you through my thesis. Okay. And my thesis is simply this, that to answer the question, and let's go back to the statute, because I want to break down the elements first. There's really 3 elements to the statute. First is that you have a serious physical or mental defect. That's number 1. Element number 2, that did not exist at the time of the officer's election. So this is something that's arisen after they became elected. And that 3, renders the public official unfit or unable to promptly and properly discharge official duties. I mean, that's the language. And so what we would ordinarily do if we had case authority is we'd be looking at what condition is it that constitutes a physical defect? What condition is it that constitutes a mental defect? And what I'm here to tell you is, as part of my thesis, is I think in this case, it depends. It depends first on what is it that the public official was stricken with. Okay, what? The other thing is when. And I say when in this sense. In the 21st century, today, or the 19th century when this statute was enacted. And I'm going to give you an illustration, hypothetical, to try to wrestle with that. And then let's kind of proceed from there and see, and I'm going to start with the physical defect aspect of it. So 1879, high public official, let's say the governor, is walking down the street 2 weeks after election, tree falls, breaks his back, renders him paralyzed from the waist down. Is that a physical defect? Well, let's think about it. 1879, this individual can't ride a horse,
cannot readily access a carriage, are no ramps, are no elevators, does this condition constitute a physical defect which did not exist at the time of the officer's election, and that makes that person unfit or unable to promptly and properly discharge official duties? I think the answer is probably yes. In 1879, that individual at that time, and I think that's why we have this statute with curious language. That's a physical defect. It would be, and those are the terms that one would use back then. Today we find that term frankly offensive. In fact, let's come forward to the present. Same facts. 2 weeks after election. Let's speed it up. Person is jogging. They didn't jog in 1879. Now we do. We're jogging down the street, we're on a path, tree falls, breaks back, paralyzed. Today, that individual would go to the hospital with the finest medical care, would go through a period of rehab where they're not performing their official duties, mind you. They're focusing on rehab. But emerging from that, would we say today that that person suffers from a physical defect arising after office that renders them unable to promptly and properly discharge official duties? Well, we know the answer to that question is no, because the governor of the state of Texas is paralyzed from the waist down, properly discharges all duties. No one would ever suggest that he suffers from a physical defect. We don't even use that language. He has a challenge. It is a challenge that he has that requires constant conditioning. None of us in this room would want to arm wrestle Greg Allen. Okay? He has to keep himself fit. But today, he does not suffer from a physical defect that would prevent him. He's got ramps. He's got access to bathrooms, thanks to the grace of God, his own fortitude, and the American with Disabilities Act. And I will refer to the ADA. I'm not going to argue preemption. But all of these things today make it possible for him to discharge his official duties promptly and fitly and ably. Okay. Now, let's go with that predicate, physical. Let's go to mental, because it's the trickier one. Okay, it's the one that is front and center in this case. And let's go back to 1879. All right, so 1879, individual takes public office. Let's say that they're bipolar, and it does not manifest itself until 2 weeks after they take office. Schizoaffective. Now, these are all terms we use today. Did not use them, because they didn't exist. Okay? Let's say that person, consistent with that diagnosis, which we had today, did not have then, spirals out of control psychotic. Which happens? Is no medication to bring them down. 1879, where do they go? What did they do with those people? Well, this is very interesting. Today, there's still an institution. There's an institution called the Austin State Hospital. They can go to a hospital to get well. Okay? 1879, what was the name of that institution? The State Lunatic Asylum. It's called an asylum, not a hospital, because it was a place that you warehoused people. Okay? It was not a place you sent them to get well. It's a place you segregated. And again, we'll refer to the ATA, not for purposes of preemption, but we'll get there. that's where they would go. And if they went there, looking at the statute, did they have a serious mental defect? We wouldn't use that term today, but could you call it that? Yes. They're a lunatic. Did it exist at the time of the officer's election? Didn't before, did now, under my hypothetical. Did it make that person unfit or unable to promptly or properly discharge official duties? No question about it. So 1879, that untreatable mental illness would render that person mentally defective and unfit to perform the duties and subject to ouster. Now let's move on and talk, with that background, let's talk about our case. And I want to do this through the voice of the state. Not my voice, not our voice. So I want you to turn to tab 3. Okay, this is the affidavit of Cindy Stormer. And let's puzzle our way through this. Because what you see here is an effort by the state in the 21st century to try to fit District Attorney Susan Hawk within the language of the statute. And this is what they say. District Attorney Susan Hawk did not appear to suffer from depression. This is the part of it. This is the number 2, the 2 element. You know, did it exist before or after? Didn't appear to require, did not appear to suffer from depression. Let's slow down. Let's slow down there. Okay? One of the things that makes mental illness such a tricky thing is you can't see it. Okay? Governor Greg Abbott in a wheelchair, you can see. And in this day and age, we're compassionate about that. You can't see mental illness. You look at this beautiful woman, you can't see it. She doesn't appear to be mentally ill because it doesn't normally appear. Let's go on. And back to the statute and the second element, which is not the most exciting one for me here, but let me do it. Truth is, in this case, she did appear before to be. If you look at the D Magazine article, which they cite, so it's in the public domain, it talks about how before her election, D.A. Hawk exhibited symptoms of paranoia. Okay, so technically, they don't satisfy prong 2, but as I said, those are not the most interesting prong. That's not the most interesting prong for me. Let me go on to the next one. District Attorney Susan Hawk did not appear to suffer from depression and did not require inpatient treatment for it before taking office. Then it goes on at the end. Before she became a district attorney, I knew of no instance where she suffers from major depression or from a mental illness so profound that it prohibited her ability to do her job. And that's right. Okay? This is a woman who, at a very young age, was prosecutor of the year in Dallas, in a huge DA's office, who served for 10 years with high distinction as a judge, like you. Never had this happen. Never had inpatient treatment for mental illness. So from that standpoint, your job's trickier. I mean, what they've done cleverly is made the argument that, well, she may have suffered from depression since the 7th grade, which she did. But it never really manifested itself in such roaring fashion until after she was elected. Okay, well, let's tease that one out. And this is critical. Never had inpatient treatment. Okay, let's go back to 1879. There was no inpatient treatment. You went to the lunatic asylum. Fast forward to the 21st century, you go to inpatient treatment. If you're the governor who suffers a broken back 2 weeks after they take off. You go to the hospital, you go to rehab. If you're someone who for the first time manifests mental illness in a way that sends you into an inpatient treatment, you say, congratulations for seeking treatment and not killing yourself. Congratulations for seeking inpatient treatment and not resigning. We know Mary Woodleaf talked her out of those things. She wanted to kill herself. She wanted to resign. She didn't. So, she has a major depressive episode. They say it. And that's right. The diagnosis was major depressive disorder. They put a name on it. It was major. It put her in the Menninger Clinic for weeks and weeks and weeks. It did. And then she got out. And let's talk about that. One part of this that I want to talk about that's troubling is the part where they say that she went to the Menninger Clinic with an unexplained absence. Okay. I think that this is the part that her good friend Mary Woodleaf, in retrospect, might have hoped would be handled differently. Okay? From the public standpoint, she disappeared. There were the headlines, "Where is Susan Hawk?" She's gone. Okay. Now, on the inside, she did some things before she went to the Menninger Clinic. She sat down, and you see the affidavit, you've read all the affidavits of our Dacina Madsen, who says, we talked about how she was going away to get better. She put me in charge of the day-to-day operations. She had 10 or more, I forget exact number, of chiefs of her various divisions, many of whom I understand are here today, voluntarily, they're not here coerced, who stood at duty discharging the duties of the district attorney's office. And when you read all those affidavits, what they tell you is that during this unexplained absence, the district attorney's office continued to operate without pause, without interruption. Okay, now, but let's get back to the unexplained absence part, right? What she doesn't tell the public? Why? Well, here's the why. Here's the difference between getting hit by the tree and becoming paralyzed and going to the hospital and getting well and coming back to work and being mentally ill. It's the stigma. It's the stigma. Okay. It used to be that you hid if you had paralysis. Franklin Roosevelt is a classic example. Okay. So he happily, by the middle of the 20th century, was able to be the chief executive of the land. But if you photographed him, Secret Service ripped that out and tore it up. Why? Because of the stigma. We didn't want that to be seen, and it's very fascinating to see how we're evolving with that. Let me just talk about that because I think it's critical. If you go to Washington, D.C. today, you'll see 2 statues of Franklin Roosevelt. The first one has him on a wheelchair, but guess what? It's completely covered up by a cloak. Okay? Now, the National Organization for Disability came along and said, no. We're going to have a statue with him sitting in a wheelchair. And that's what they did. So there are two statutes. The cloaked statute, older. The uncloaked statute, new. And that's because our attitudes, societal attitudes, towards physical disability have evolved dramatically. And in this area, Greg Abbott, our governor, is a hero. Let me explain why. I'll tell you why I think he's my personal hero. When he greets any other individual in a wheelchair, what does he do? He says, hey, tree fell on me, what happened to you? To destigmatize it. And to serve as a role model to say, what I have done, you can do as well. I'm in a wheelchair, I'm the governor, the second most populous state of the country. And here's the problem with stigma. So that's what makes you surreptitiously go to seek treatment, which is what we should be encouraging. That is treatment. Without the stigma, I mean, hopefully we'll come to the day where if you're stricken with something like this, you can go to the press and say, time out, I need to go to the medical clinic, and everybody cheers and says, good, go, recover. But in this case, what happens? You've read the allegations. Couple things. One is, it's so easy with mental illness to blame all evils on it, or perceived evils on it. And so what we have is riddled throughout the state's petition is that the only possible explanation, for instance, for the discharge of Cindy Stormer, is because Susan Hawk was paranoid and delusional. That's the only possible explanation. Well, you've read the affidavit of Ms. Manson, which tells the true story. And I'm not here to slam Cindy Stormer or anyone else who's discharged. Those are sensitive issues. I will say this, by way of example. At the same time that Susan Hawk took her position as district attorney of Dallas County, right next door in Fort Worth County, another district attorney took the position of DA and fired more people, which was considered a morale problem. But nothing that would ever suggest ouster, and there's a reason for that. Under the statute, when you look at incompetency, none of those statutory grounds for ouster includes personnel decisions, nor could they. That is a Rubicon this court should decline to cross. If you were to take the step of saying that personnel decisions are fair game, that's going beyond the plain language of the statute, and it's trope.
In fairness to the state's position, don't you think they're not saying she fired people, but that the conduct surrounding those firings was erratic, etc., and that
Well, maybe it's a matter of interpretation. I read it that it's not just that the conduct was erratic. The way I read it, perhaps wrong, is that explains the fire. In other words, the paranoia, the delusion is what explains the fire. That's the way I read it. Could be wrong. Okay? And I guess
Mark being a Beth, their relator, Cindy Storm, I just want to interject one thing into the mix here. Before the state, it has a submitted affidavit from Mr. Bill Worshby, who's one of the best prosecutors, I think, in the state of Texas. We're framing this as a mental health issue, but part of the allegations are drug use in the office after the election. And I don't think that should be overlooked as you consider what the allegations are.
Okay. So that may be, there may be differences of opinion as to how that's being explained. I think that the one thing, though, in terms of the plain language construction, Your Honor, is that there is nothing in the statute that would permit personnel decisions to be a basis for custody. And I think that that's critical. And that's because under the Constitution, under the governing statutes, wide authority is delegated to the district attorney as to other public officials for purposes of discharge. Okay? Now, the second allegation that I think fairly is... Yes?
I don't know the situation in Fort Worth. I know that former Judge Wilson was elected, but did she hire people that she had brought in herself, or did she do some house cleaning of people from the previous administration?
I think it was largely housekeeping. I don't know. That's an excellent question.
Go ahead.
Yeah, I don't know. I do know that ultimately it was about 17% of the district.
Judge, Mr. Wright could actually respond to that.
You can wait your turn. Go ahead, Mr. Alexander.
Yeah, okay. I don't know.
I think I know the answer, but go ahead.
Okay. Okay. And so let me go on to the next point, which is, besides the fact that it's easy to blame conduct such as this type on someone who's mentally ill, the other allegation that they make is dereliction of duty. What they say is that by virtue of being gone for 11 weeks, she was derelict in her duties. And this is where I do want to go to, let's go to tab 3, which is, I'm sorry, tab 4, which is the ADA. And the predicate finding, I'll just quickly read it, is that Congress finds that physical or mental disabilities in no way diminish a person's right to fully participate in all aspects of society. Yet many people with physical or mental disabilities have been precluded from doing so because of discrimination. Others have a record of disability or are regarded as having a disability, also have been subjected to discrimination. And this is, I think it's important to understand this for this reason. If a governor 2 weeks into office is struck by a tree and paralyzed, nobody would ever call taking 11 weeks off for surgery and rehab as a dereliction of duty. If someone 2 weeks into office was diagnosed with stage 4 cancer and took time off to go to MD Anderson to get surgery and then go through a period of chemotherapy treatment, no one would suggest that that's a dereliction of duty. And yet I think it's fair here to say that their allegation is that that was a dereliction of duty. And they use that language. So let me then go back to where we started. And that is to look at the Ulster statute. And I want to read this. Because this again, I want to do this through the voice of their pleadings. And I want to take it measuredly. This is on page 10 of the state's plea.
Second Amendment.
Second Amendment, page 10. It's the part that starts with the word "since the defendant's return to work."
Okay.
Okay, and I want to take some time to work through it. Since the defendant's return to work, she has admitted that she suffers from major clinical depression. True. And also attention deficit disorder. Also true. Further, she has admitted to struggling with thoughts of suicide. Correct. That is a all too unfortunate byproduct of major depression. And also to having abused or become dependent on prescription medication. She was upfront about that as well. Before the election, she had spent a time in rehab for abuse of prescription drugs. Admits that. Went to rehab. Took care of the problem. Let's go on. While the defendant now claims that she is stable, okay, I would modify that to say is stable, not claims. All the affidavits support that. And that she has these problems, quote, under control, which they are, then let's slow down here. These problems remain serious enough to require her to participate in frequent therapy sessions and to take daily doses of medication simply in order to function. Your Honor, for someone who has suffered depression, that is exactly what you want them to do. Go to regular therapy sessions. Take your daily medication. Where we get into trouble is where people who suffer from mental illness don't do that. And yet here, what is the very next sentence? The combination of these physical defects and addictions and these mental defects help explain behavior. More important, these defects, in the manner in which they have become manifest, have rendered the defendant unfit and unable to discharge her official duties. There is no question, Your Honor, that for a period of time, a year ago, spring of 2015, she had paranoid delusions. We're going to be talking in a minute about some of the more specific allegations of conduct. But that was true. But I think we have to read the statute this way. This is the temporal aspect. What they like to say is, if this happened in the past, you can be punished for that, or that's grounds for ouster. I think we need to look at it this way. If you suffer a physical defect because a tree has fallen on you and you take time to treat it, if you suffer a physical defect because you have been stricken with cancer, you get to treat it, and then the question is going forward, are you, and this is using the language of the statute, are you fit and able to promptly and properly discharge official duties now, today, once you've completed that treatment and are continuing to take care of yourself? And again, I said defect, but would we really say that Greg Abbott suffers from a physical defect? Is that a term we would use? And yet in their pleading, the state, led by a man who was paralyzed, say that she suffers from both physical and mental defects. Today suffers from physical and mental defects. Okay, that's just wrong on so many levels. Greg Abbott faces challenges. It is not easy to run a state from a wheelchair, but he is not physically defective. She faces challenges. It's not easy to run an office of 450 district attorneys when you are mentally ill, when you do have to seek physical regular therapy, when you do have to take medications daily, but she's doing it. Greg Abbott is a hero and is recognized as such. I'd be naive to say that we've evolved to the point where we consider people like Susan Hawk a hero. We haven't, sadly. We should. But the key point here is we're not here. Well, let me digress a little bit. This notion that somebody that suffers from severe depression cannot be a leader. Let's talk about Abraham Lincoln. He suffered from severe depression throughout his administration. The greatest president in our history. Let's talk about Winston Churchill. Perhaps the greatest leader in the 20th century. Suffered from severe depression. He called it the black dog. The black dog would visit. Now, how do we know this? Go to the website of the National Alliance on Mental Illness. Look up Abraham Lincoln, look up Winston Churchill, and they talk about it. And why do they do that? And why have they weighed in this case? They do that as an inspiration for people. Who suffer mental illness. Craig Abbott is an inspiration for people in wheelchairs. Susan Hawk should be an inspiration for people with mental illness. Instead, she's on trial for ouster, or they want to put her on trial for ouster. I want to go through, this is why I want to conclude by just going through the three elements. The three elements here. 1, does she suffer from a serious physical or mental defect? No. She suffers from a serious but treatable mental illness for which she sought treatment and is now maintaining herself. That's the language that should be used in opinion on issuance of citation. Second element, that did not exist at the time of the officer's election. She has suffered depression since the 7th grade. The fact that it didn't manifest itself in a not only massive way but a public way until after she's elected shouldn't be the construction of the statute. It pre-existed. It just simply did not manifest itself this way. But the final one is the key. Does her mental illness render her unfit or unable to promptly and properly discharge official duties? In the same way that Greg Abbott today, probably not in 1879, can discharge his official duties ably, so can she, and is. And with that, I'm going to turn it over to Mr. Walker to take care of some other aspects.
Thank you, Your Honor. I'm going to focus on remaining allegations, which fall under two broad titles. The state on page 7 of its second amended petition.
Page what was that?
Page 7, Your Honor. The state turns to two other provisions under the statute. Under the incompetency definition, there's an A, B, and C. A is gross ignorance of official duties. B is gross carelessness in the discharge of those duties. And C is what Mr. Alexander just discussed, which is the issue of physical and mental defect. We've covered C. I want to cover A and B, which are the other two grounds that the state has requested citation to be issued on. First and foremost, Your Honor, I think it's important to note two legal principles that I think have to govern the court in evaluating this. And that is, what does the word gross mean in each of these definitions? And I think the court has to note that it is tied to the issues of duties. In the case of DeAndre versus State, the court there said that the word gross is analogous here to the gross negligence standard we use in common civil law. That is, it's not enough to show that someone did something merely wrong or made a mistake or anything of that nature, but it's much more elevated than that. It's an issue of intent. It's an issue of the mens rea of the individual. In civil cases, when we talk about gross negligence, we discuss that somebody had a conscious awareness of an extreme degree of risk, but a reckless disregard of that risk. And I think when we look at each of these, which we're going to go through each of the allegations contained in the state's petition here, you will see that what they are arguing here is not something that will rise to the level of a gross carelessness or a gross ignorance. Frankly, I don't think it arises even to a simple level of carelessness or a simple level of ignorance. But it certainly doesn't rise to the level of gross. And if you look at them each singularly, you will see that none of them reach this level. The second is that both provisions there of incompetency is tied to the issue of duties. Gross ignorance of the official duties of the office of the district attorney. gross carelessness in the discharge of those duties. And here, the focus has to be on what are the duties of district attorneys. And that's an issue of law, Your Honor. The district attorney's office, what their duties are to prosecute cases in the name of the state of Texas. That's in the Code of Criminal Procedure. Each district attorney shall represent the state in all criminal cases. That's one of the duties. The government code provides additional duties, such as the criminal district attorney shall collect the fees and commissions provided by similar services rendered by district or county attorneys. They shall report at times to the commissioner's office. These are the duties of a district attorney. And nowhere in the state's petition is there a reference to any actual duty of the district attorney's office that was ignored or not met. It doesn't exist anywhere in that petition. And I think it's important here, Your Honor, I'm going to show the court two, may I approach, Your Honor?
Yes.
Two quotations I think animate this discussion. One comes from the last time the Supreme Court of Texas addressed the ouster statute, N. Ray Wolf. And it discusses, but individual citizens have no private interest in ouster distinguishable from the public as a whole. The remedy of ouster is one which belongs to the state in its sovereign capacity to protect the interests of the people as a whole and guard the public welfare. That's the purpose of this statute, protect the public welfare. Make sure the district attorney is performing the duties necessary to protect the public. Is there any evidence anywhere in this petition? Is there an allegation anywhere in this petition that the public was exposed to any danger, that the duties were not met? The second quote I think that needs to animate this discussion comes from Reyna versus State. Before a public official will be removed from office for failure to perform a duty, exactly what the allegations are here, the law must have plainly enjoined such a duty upon him or her. So with those guides, let's turn to what the actual allegations are. On page 7, the first one, right out of the bat. The defendant, the district attorney, proved to be grossly ignorant of the legal requirements that regulate the use and disposition of certain restricted funds entrusted to her office. Now, what is the factual basis for that claim? We have two affidavits of individuals who speak to this allegation. The first is Cindy Stormer, which was with the original petition, and the second is Jennifer Belito, who's filed an affidavit in support of the state's petition just this Tuesday, I believe. And Your Honor, in the affidavit of Ms. Belito, I think, gives us some very good guidance as to how we should evaluate this claim that D.A. Hawk was grossly ignorant of the laws and regulations governing these funds. This is the affidavit of Jennifer Belito, and she notes in her affidavit on page 2. It's too far. Ms. Belito had the position of Administrative Chief of Finance. That's also what Ms. Stormer had as well. One of my first duties as Administrative Chief was to review all of the funds overseen by the District Attorney's Office, the funds discussed on page 7, to determine the balance in each account and to determine what was or was not a proper expenditure of the money in each account. It is Jennifer Belito's duty, just as it was Cindy Stormer's duty, and just as it's Mr. Costello's duty now. It's the duty of that position to determine what was and what is not a proper expenditure of the money in each account. It is not a duty of the district attorney elected and sworn in on January 1st to just know, to arrive on the scene with a perfect knowledge as to how each of these accounts should be operated. There are people in her office that do that for her. Indeed, Ms. Belito said it is her duty to do it. She goes further. The district attorney's office has a number of bank accounts holding funds from various sources, and each account has different statutes that regulate how those funds can and cannot be used. So each of them have different statutes. Ms. Hawk was concerned about these counts because there had been some accusations from her campaign in the media that the funds were not being properly used by the previous administration. So DA Hawk, far from wanting to misuse the funds, was concerned about their proper use and charged Ms. Polito to go and review that. And here, I think it's important, I reviewed the funds and researched the legal issues surrounding the expenditures from these accounts. Ms. Polito, who, as her affidavit shows, is a highly qualified person whose qualifications are actually very similar to Judge Hawk's. She was in the district attorney's office, and she was a judge as well, and she arrived in January of 2015 to perform this task, just like Judge Hawk. She had to go do legal research to figure this stuff out. She did not arrive in January with a perfect working understanding of all these funds and how they should be used. It was a task that she was charged with, and she had to go research herself. Now, turning back to the state's petition, let's review the language here. After assuming the office, the defendant proved to be grossly ignorant of the legal requirements that regulate the use of those funds. Again, was it her duty? No, it was not. But assuming, for purposes of the argument that the state advances, she should have known. Can this court, is this court going to endorse the argument that somehow DA Hawk asked the person charged with those duties questions, that is an indication she's grossly ignorant of her duties in a way that jeopardizes the public? Because that is the tie for all of these arguments. As the Supreme Court noted in Wolf, the issue is this necessary to protect the public welfare? Is the elected official not performing their duties in a way that jeopardizes the public welfare? Is DA Hawk asking a question about how an account should be used, is that a gross ignorance of a legal requirement that she had a duty to know, and that her asking questions jeopardize the public? Of course not. The state continues. The defendant frequently made or attempted to make improper and unauthorized use of such funds to pay for office equipment and furnishings, to pay fees and salaries charged by consultants, and to pay for personal political activities such as associated with the celebration of Martin Luther King Day. Let's break that down. Made or attempted to make improper and unauthorized use of funds. What is the evidentiary basis for that? The evidentiary basis in the affidavits is the contention that the DA asked questions, requested that funds be used in certain ways, and was told you cannot do that by the person whose job it was to go do legal research and figure that answer out. Is that a duty of the district attorney's office for which he is grossly ignorant and it jeopardizes the public welfare? No, it is not. The questions were asked and the answer was given, no, you cannot do that. That's not grounds for ouster. There is no gross, in the term of gross negligence, ignorance, or carelessness as evidenced by that.
Let me ask you how much more time you want to use.
Your Honor, 15 minutes?
I just want to be sure we leave plenty of time for the other side. Go ahead.
Thank you, Your Honor. The same as with the fees and the salaries, Your Honor. Questions were asked, answers were given, you cannot do that. That is how the office operates. We submitted the affidavit of the individual who currently has that office, Mr. Kendall Costello. He currently has the position that Ms. Stormer had and Judge Polito had. And in that affidavit, he states, just as Jennifer Polito, it's his job to provide advice and guidance regarding those purchases, and he has never seen anything inappropriate, and Judge Hawk has always followed his advice despite questioning. This last one here, to pay for personal political activities. And this is sort of a mountain out of a molehill. This involves the purchase of candy for a parade.
Candy for what?
A parade. A little more context is provided in an affidavit provided to the court last night by Mr. Glenn Fitzmartin, who explained this whole candy situation. It turns out the district attorney's office, over the years, has participated as a matter of community outreach in a Martin Luther King Day parade to get out there and be present in the community. The accusation as contained in these pleadings is that someone said there should be candy purchased, and Judge Hawk said buy the candy, and whether or not county funds should be used to buy that candy is somehow an issue apparently that they believe satisfies ouster. But what we know is that funds were used by individuals to purchase a small amount of candy, and that D.A. Hawk had nothing to do with that. The decision to purchase the candy and to try to participate in this parade, as Mr. Glenn Fitzmartin said, it was his decision-making. It had nothing to do with D.A. Hawk. These decisions, whether or not you can second-guess them, do not rise to the gross level that is necessary here. Going further, they have a whole paragraph dedicated to the fact that the defendant proved to be ignorant of the fact, on page 8, that because she's a public servant, she's not required to pay the state's attorney occupation tax. Again, simply, is that a duty that the DA has? The qualifications for a duty is to be a licensed attorney and win an election. Knowledge, perfect knowledge of the occupational tax code is not one of those. There are people who decide that for. Trying to take that bit of information and transmute that into an indication that someone is just grossly unaware of the law and they have to be discharged is simply inconsistent with the purposes of this statute. The same contention goes to the issue, and I'll speed up based on the court's questioning, with respect to these staff salaries. The same arguments. Questions were asked, decisions were made based on the advice of the individuals present. It's not an indication of gross ignorance or carelessness because somebody says, I disagree with the DA's question or the DA's purpose in making those requests. So I want to turn to the next one is mismanagement. The other two grounds for carelessness are this mismanagement of employees, which Mr. Alexander addressed, and the gross carelessness by leaving. Again, we have to be informed by the words here of gross and duty, and nowhere in the context of this allegation or this petition is there any indication that there was ever a statutory duty not met. So in summary, Judge, Your Honor, I would ask the court to think about this with the seriousness which the state admits is necessary. This is a very serious issue. There are matters both of the law and public policy here. Are we going to permit employees who are discharged to just file an ouster petition within a month of their discharge, make a bunch of allegations, and attack someone's mental health? Is that going to be something we're going to greenlight going forward? And I submit to Your Honor that that would be an idea that is both dangerous and unproductive and inconsistent with the law. There's no indication that the duties of the office of the district attorney have ever been impaired. There's no indications that the duties of the district attorney's office have ever not been met. The only real contention here is we have disagreements from employees with the DA, none of which rise to ouster, and that DA Hawk bravely sought treatment for a mental condition and is doing just fine. And the court ought not allow this to continue further and ought not send the message to both Judge Hawk and to everyone who thinks about running for office in the future. If you have a mental condition, be prepared. Because if you're elected, someone can file a petition and dig into your mental health background and try to oust you because of something that a doctor wrote on your medical records years before. The condition suffered by D.A. Hawk does not rise to the level of ouster because it pre-existed, and it is not simply a defect that prevents her performance in office. So we would ask the court to send a strong message by refusing to issue citation. Thank you.
Yes, Mr. Wilson.
I think I'm going to be pretty brief. I think what we've heard from the defense is a remarkable closing argument for a jury trial. A lot of facts have been argued here before the court, but that's not the purpose of this hearing today, to weigh the underlying merits of the petition. We believe the state has made sufficient allegations to meet the threshold for the court to issue citation. A couple of responses to some things that the defense said I'd like to touch on, however. I think it's remarkably disingenuous to liken mental illness to a physical defect such as a broken leg. If it is a job requirement of someone to run a relay race, then a broken leg is going to disqualify them from that job. The district attorney especially the district attorney in a very large metropolitan jurisdiction of Dallas County, that job is largely a mental job. And if someone has a mental defect that renders them unfit for that job, they should be removed from office. Furthermore, present behavior is no defense to past conduct, Your Honor. And the greatest observation I'd like to make to the court is we've heard and seen lots of affidavits, sworn affidavits, from lots of people. We have not yet received a sworn affidavit from Ms. Hawk. We've not yet received a sworn affidavit from Mary Woodley. We have not yet received a sworn affidavit from a medical provider. We do not know what Ms. Hawk's mental or physical condition was at the time of the allegations that are the basis of the state's petition. And I think that's profound at this point in time, Your Honor. This narrative, and that's what it is a carefully crafted narrative that she's had mental illness since she was in the 7th grade. Frankly, that's all simply, the basis for that are well-crafted interviews that she engaged in as part of a public relations campaign only in response to mounting public questions about her conduct and, frankly, her whereabouts. None of those statements are sworn. She at no point in time has bothered to swear to the veracity of any of her claims of her mental health. And I'm reminded fundamentally of the objection we all learned as our first-year law students in mock trial. When the other side would make a motion for directed verdict, the narrative we learned was, Your Honor, I think sufficient evidence has been submitted such that reasonable minds could differ. We have allegations that I believe meet the requirements of the petition. Some of the affidavits that were filed late yesterday by the defense, frankly, even corroborate that there were concerns about the state of her mental well-being. You know, on November 3rd, 2015, that morning, the Dallas County Commissioner's Court appointed me to take over this case. And almost the exact hour that that court was meeting, I was unconscious on an operating table right here in the city of Dallas because I had a physical defect that needed surgical repair. Yet that afternoon, I was running my office. Thanks to the wonders of modern technology, while I was recovering in my bed, I was able to communicate with my office. I was able to direct courses of action in response to things that were happening in my office. So I think it's absurd that in the year 2015, we can suggest that someone can just disappear for 11 weeks from an office as important as the Dallas County District Attorney, and that's okay. Your Honor, there's simply, at this point in time, there has been no evidence at any point in time submitted of what Ms. Hawk's mental condition was at the time of these allegations. There are suggestions that she may have been abusing drugs, legal or illegal drugs, yet she has simply crafted a narrative that she was suffering from depression, and I submit to the court that's nothing but a PR campaign, and that's not sufficient for the court to make a ruling. We ask that you issue the citation.
Let me ask your side of the case a question or two.
Yes, Your Honor.
You mentioned, you said present behavior is not a defense to past misconduct. But Mr. Alexander said that in effect, you remove for incompetence or unfitness now. And so I want to raise the question of, and understandably, because the 5 affidavits that you have submitted are from people who worked there and then were fired in early 2015. They're not there now to testify about now. But other people are. And so if someone has, done things early on in 2015, gotten treatment, and is not still doing those things, and things are running smoothly, which is what the evidence, the other affidavits say, why should that case proceed?
Well, again, Your Honor, that assumes facts not in evidence, fundamentally. But first and foremost, the statute doesn't contemplate that. And the simple fact of the matter is the statute simply says if there is misconduct, if there is gross carelessness, etc., at any point in time, then that is sufficient for removal. Simply put, the statute doesn't say if this happens, but then everything's okay later on, it's okay. There's not a King's X provision in the statute. It's like if a train derails, Your Honor. Train goes down the track and it derails, it causes a big mess. At some point in time, the railroad comes along and picks up the train and it goes on down the track and it's fine, but there's still a big mess that gets left behind. And that doesn't absolve what took place in the past, and the statute provides no out on that basis. Just like any sort of I mean, I don't want to analogize this to a criminal prosecution, but because criminal conduct can be part of the removal statute, I don't think it's an inappropriate analogy. If someone commits a criminal act, but then by the time the case comes to trial, they're a choir boy, that doesn't excuse the criminal act. And that's the best analogy, the simplest.
You used the word absolve, and so let's talk about it. Is this a case about punishment for misconduct, or is it a case about being sure that someone who holds an office to which the voters elected her should continue in that office? And do you not focus on, I think, the situation now as opposed to punishment?
I think it's the latter, potentially the former. And that relates to this forgiveness doctrine that was touched on just briefly by the defense. It's been, the argument is being made in practical sense that, well, she had this condition before she got elected. She's had it since the 7th grade, therefore it's all hunky-dory. We don't know that, Judge, and certainly the public did not know that before she got elected, and so I think, again, that's a disingenuous argument to make. But if it's about making sure that someone who is mentally fit is in office, we don't have enough evidence to determine that at this point in time.
Yes, go ahead. Why don't you remember what you want to say, but then, and then if you want to have it, that's fine. Hypothetical. Let's say there's a county treasurer elected by the voters and put into that office. And he shows up for work in the first few months of the job, he cannot get the books balanced, cannot get payroll paid on time. The money that comes in, receipts, doesn't get them accounted for and routed to the right account, just doesn't know how to do it. But learns how to do it. Gets a mentor, goes to some education, and so forth. But the first few months of the job, it wasn't getting done right. But now it is. Now, that's not exactly our situation, but just for thinking it through, should that person be removed a year into the office for inability to do the job? I'm not saying this all, facts of this case, but hypothetically. Should the treasurer that I'm hypothesizing be removed for inability to do the job the first few months of his or her career, when now they're doing okay? That's the question.
I think we had that treasurer in Ellis County one time. I think the answer to that question is potentially. If someone files a petition making allegations of gross carelessness, and there's an opportunity to explore those allegations, I think the best and most honest answer is potentially, depending on what the facts and the evidence may show in that particular case.
Yes.
Your Honor, Mark Haney again on behalf of the realtor.
Mr. Walker, I'll call on you.
Well, respectfully, Your Honor, I would like to interpose an objection, and the reason why is simply this, Your Honor. We've had the kind of realignment of parties, and I think it's clear the state is the party moving. And earlier, Mr. Haney spoke, and he was starting to make arguments that may have existed in Cindy Stormer's original application, but are not in the state's amended application.
If Mr. Wilson is content for him to speak on his side, he can do it. You okay with it?
That's fine.
Go ahead.
Your Honor, I just want to bring to the court's attention, I think what the court's asking for, is there current evidence, is there current information that's being out there about how Ms. Stormer, Ms. Hawks operating her office? And what we have been receiving in our office since the time of the filing of the pleading are anonymous calls for people alleged to be in the office of the district attorney claiming she remains not present on the job, and they're continuing to have issues and questions about her fitness for the job. They're afraid to be known because they're afraid they'll be terminated. But I think we don't have the opportunity to explore that evidence under the cloak of the and protections of the lawsuit.
Yeah, let me follow that up. I think probably one reason that you can have a seat, because I'm going to take a while to answer my question. I think one of the reasons why we have provisions like this removal and gatekeepers, for lack of a better term, like you have to be here for state and the judge from the outside has to sign off on it. And one reason for that is that to allow a trial and the pretrial discovery and diversion from work and so forth. I mean, and money cost is another thing, but to allow that is not a cost-free process. It's a cost-heavy process in terms of the human impact on it. And I think probably the lying behind this law and the gatekeeping aspects of it is a recognition that to go through the process and achieve perfect truth and interview people and so forth exacts heavy costs, and the whole end goal is to take from office one that the voters put there. So those costs, it seems to me, have to be thought about. And so let's talk about that. And I think that's raised by your question. Let us go forward and we can interview people, go through discovery and that kind of thing. But that's not a cost-free process.
I agree wholeheartedly, Your
Honor. Now, you wanted to say something in response, I think, Mr. Walker.
No, Your Honor, I just wanted to make sure we were focusing on the petition at hand as opposed to extraneous allegations and arguments that we had no evidence of.
Your Honor, as an aside, one thing I forgot about, you mentioned earlier, if you are interested in hearing the corollary about Tarrant County, Mr. Wright was a 27-year employee of that office who then retired when the new administration came in. If you're interested in hearing that, I just wanted to make you aware of that.
I simply asked if there's a comparison between Dallas and Tarrant County. You've got people who were fired by the newly elected DA. If those are truly comparable situations, I was just wanting to know whether in Tarrant County people that Sharon Wilson had brought in herself, if she fired them or if she fired people who were already there. Is it the latter?
Well, I think it was a matter of...
You brought it up.
Exactly. And what I'm saying is, to Your Honor, it was a matter of an ill-advised argument on my part. Okay? They got us diverted onto a subject that need not be at hand. So let's erase Tarrant County, and then we don't have to go into an explanation.
I don't want to erase this question. Yes. Several people chose to resign before she took over. Some back in...
Several who were already there?
Several who were there.
Previous administration.
Previous administration chose to resign before she came in. Some chose to retire before, at the end of Joe Shannon's term. I was one of those people. She asked me to stay for a month and help out. So I chose to stay. She brought in, some people were, she believed, I suspect, I don't know this, I wasn't part of the team, but some people were told they weren't going to be in charge of things they had been in charge of, and that in a year or so their salary might be reduced. There was one person that I'm familiar with that she brought in as her team that was fired.
So it's a mixed, okay.
And other than that, I don't know of people. There are people who left after she, but none of them raised allegations.
Okay.
Your Honor?
Yes.
Just since I was charged on behalf of the state to speak to the specifics of the petition, I would like to recall us to the issue at hand. Under the provisions of section 87.015C of this statute, there is a requirement for a petition that must set forth the grounds alleged for the removal of the officer in plain and intelligible language.
I want to see the language. Tell me again where it is.
It's 87.015 subsection C. It's the requirements of the petition. The petition must set forth the grounds alleged for the removal of the officer in plain and intelligible language, and must cite the time and place of the occurrence of each act alleged as a ground for removal with as much certainty as the nature of the case permits. This, plus the provision of this statute that requires the court to conduct this proceeding insofar as possible, in accordance with the rules of procedure in a civil case, dictate what our obligations are and what's really before the court at this time. The state certainly accepts and respects the court's recognition of the larger issues at stake here. But when you look at the way the statute seems to contemplate the proceedings to go, a petition is filed, no citation is issued, so there's no appearance made by anybody. So what does the court have to look at? The petition and what information goes with it. Presentation here today is, as Mr. Wilson said, a jury argument. It assumes that all evidence has been made, a determination has been made as to what is admissible and what's not. They would have you believe that whatever information we offered is to be disregarded and theirs to be accepted. That's not what we're about. That's not what we can do right now. What we can do right now is comply with this statute and with the rules of procedure and provide fair notice and a plain statement of what our contentions are. We believe we've done that.
Are you contending that I should look only at the allegations that you made in your second amended petition and not anything else? That sounds like what you're saying.
I'm saying that the procedure doesn't seem to contemplate anything else. I mean, how does somebody who's not made an appearance make an appearance? But that's really what I want to come back to, is if you accept the jury argument made by the defendant, it assumes that the ambit of all known facts has been established, and that all we're doing is arguing about what difference those facts should make. And we are a long way from that. We haven't done that yet. We believe that we're at a preliminary stage where we present sufficient information, legal authority, and a petition in plain language, and providing fair notice to justify service of this citation. Essentially what the defense is arguing is a general demurrer or a 12B6 motion, which is not provided for in Texas practice at all. And that's an issue that I think is what's specifically before the court today. Whether we can get to the next stage and determine what evidence is true and what evidence is not, and what should be done going forward towards a jury trial.
Okay, what else does anybody have? Got plenty of time now, and I want you all to say what's on your mind. I don't want a bunch of repetition of what we've already heard, but if there's something new or that'd be helpful, I ask everybody on this side of the rail to stand up and talk.
Your Honor, I believe the state has presented everything we'd like the court to consider in this matter.
There's no further questions, nothing further.
Anybody? I'm going to issue a ruling. Let me say a couple of things first. I want to commend the lawyers for the first-rate everything and arguments, and I appreciate it on all sides. I'm going to caution everybody in the courtroom. I'm going to rule, and then I'm going to walk off the bench. I don't want any audible reactions till I'm out of here. Okay. The citation that was previously issued by the district clerk is quashed. That's number one. Number two, the request that I issue an order requiring citation to be issued is denied, and the petition is dismissed. Thank you all very much.
All right.
Mr. Wilson? Mr. Walker? Yes.
Can I get, we have,
Yes.
how many does you like, David?
Yeah, that one's mine.
Hey, I tried one day, she may want to do
Yeah, thank you.
Stand up. Like this morning?
I had a trial with you once, young man. I'm trying to remember where the hell it was, because you kind of filled in, maybe it was Beecher Benson one day. No, I tried to get some Shaw in here, so trial. Hey, great guy. You kind of parachuted in, did a couple stages.
He's good at that.
Hey, Susan, you're going back to work. Well, you did it, Joe. Hey, I follow what made it even look worse. Just saying. Brazil, come over here. Now what? Let me tell you. Sure you are. Steam and the stream.
Thank you very much.
I'm a kangaroo. I went to junior college first.
Yeah, they get you.